o'clock. So welcome. As you can see, a message would have just been popped up on your screen to say that we are recording today's session. So here we are at the critical considerations for mergers and acquisitions, and it's going to be a legal overview on due diligence and who should act for you. So today we are joined by Richard Phillips and Penny Bygrave, and today's session will be considering some key decisions and working practices around mergers and acquisition deals, focusing on advisors and due diligence and the importance of thinking about who should act on your behalf. So the session will cover when to involve the experts, the role of experts, legal due diligence ground rules, common issues arising with data protection, IT and IP, and after the deal is done, where do you go from there? So first of all, I would like to welcome Richard Phillips, and I will hand over to you.
Emma, thanks very much for that, and to everyone, thanks for coming along this morning. Lots of talks that you'll see, either that you attend or that you see advertised from lawyers and others about M&A transactions, and sort of just try and sort of cover the whole thing in one, really. But Penny and I thought today that we'd steer away from the generic, this is a deal and this is how it works, and concentrate on two particular facets. We'll talk about advisors and experts, and we'll talk a little bit about due diligence. I'm going to just be thinking in headline terms about the key sort of macro elements of due diligence. And Penny, almost I think by way of case study, will focus on what are always key areas of due diligence, namely data protection, intellectual property, and IT. I think that will then give quite a lot of insight into some of the common issues that come up and link with our thoughts on which are the right experts to involve. And when Penny's finished her bit, I'll conclude by referencing a few examples of why you're going to need experts for some while after the deal is done and the metaphorical ink has dried on the contract. So that is, I appreciate, a somewhat dated simile, given what I'm going to say around electronic signatures. So next slide, please. So when to involve the experts? Well, the one-word answer really is early. And good advisors are going to add value, and even more so if they're involved from the outset. And I'll give an example around due diligence shortly. I can't actually see the slides, but that's not a problem if they're not coming up because I've got them elsewhere. Thank you very much. So I'm going to give you an example around due diligence shortly, but I'd like actually first to run through several other areas early on as to where experts should be involved. And the first thing really is obviously, in a way, starting right from the beginning. That is the initial selection of a deal partner by a person wishing to sell their company or by a buyer who is on the acquisition trail. And actually experts can really help in that selection process. A corporate financier will have a lot of probably sector knowledge because you've employed that person to do a particular job, and often will go out as perhaps acting on behalf of the buyer and find suitable acquisition targets. Equally, sellers wishing to sell might want to have someone act for them and find a buyer. And that knowledge will be used to ensure that there's the proper fit, given what people want. Maybe there'll be a knowledge of that party's, if it's a buyer's, previous behaviour, if it's a serial acquirer, and there may be certain pinch points around how that buyer would act. You might end up with 4 potential people to buy your business if you're a seller. Actually, one of your key considerations is that you want to continue on in the business afterwards and don't simply want to walk away into the sunset. But actually 2 of the 4 buyers, maybe 2 which are offering the highest price, might actually want you to walk away and not continue on in the business. well, that might actually make your decision, and you've then got 2 to choose from rather than 4. But yeah, a good corporate financier will be able to really help around that whole selection process. Heads of terms are probably all of you aware, but not just in deals, but in commercial transactions as well. Often something where you will get to when a buyer and a seller have been talking and coming to a headline commercial deal in terms of the price and the core components of the deal. And it's always really, really useful and advisable to get experts, advisors involved in those in the very early stages. They'll help to shape the deal. If there's something that the parties just haven't thought about, which from a legal perspective might make it a real problem later on, then that can be ironed out at that point. It can cover off issues. And although they're non-binding, heads of terms are difficult to row back from commercially when you get down into the main negotiation. So if you're a buyer, for example, you will want some exclusivity, and usually a lawyer would help you draft that exclusivity to make sure that you're not spending lots of time and money on a potential target, only to find that it decides to go with another buyer. Structuring transactions is also an area where very early on you could get real value out of expert advice, not least tax. The very simplest example, if a buyer is interested in a company but wishes to simply buy the business and the assets rather than the shares, that might just be a no-go from a seller's point of view because of the tax advantages that it would lose out on by not selling the shares, but instead allowing its company to sell the business and assets. And there's some pre-deal restructuring which might really help. It might actually help get the buyer to want to buy in the first place. If, for example, there are 2 divisions in a company and a buyer is very interested in one but not the other, and there may be a way of taking out the other one in advance of going through a sale process. There may be a property in there which might actually have an adverse effect on the tax, and there are ways in which that property might be able to be moved out, but all of that requires real expert advice. And one of which I came across quite recently. I wasn't acting on the transaction. It was a fairly small deal, and the target was an unlisted public limited company, not listed on the exchange, and so effectively like a private company. Now, that sounds therefore that you probably treat it in much the same way as a private limited company, but it does get caught on a sale by the city code on takeovers and mergers because it is a public limited company. And for small deals, sometimes that can be out of all proportion to in terms of the work involved and the time taken to get it across the line. It's not impossible, but it does involve quite a lot of work. And so maybe the answer there would be to, if you have enough time beforehand, to actually convert that public limited company into a private limited company, and therefore you negate all of the issues around the regulations. Just an example of how, from a structuring point of view, it can really help to have those experts involved. And just a tiny bit on startup and the startup and the scale-up world. At VWV, we do a lot of startup and scale-up tech work. One of my colleagues here today, Emma Cameron, does a lot of work in that sphere. And it's so important at the outset of these companies' lives to make sure that they're structured correctly, that the shares are properly issued, that there's a sensible shareholders agreement, which perhaps doesn't give too many rights to minority shareholders, which are difficult to reverse out of when perhaps you come to a second or third funding round, when, say, a PE house comes in and wants to actually put serious money in. And the work that a tax advisor would do around EIS and SEIS to get the tax right at the beginning, if that's not done correctly, it can actually mean that funders might walk away because it's just too difficult to deal with the situation. So Sarah, next slide, please. You'd expect me, I suppose, to major on lawyers, so I'm going to do that for a moment and just talk about the role that is played by lawyers. What type of lawyer should you have? Well, one recommended, normally a very good source, But I would just say be alive to the genuineness of the recommendation. You do find some people, not a lot of people out there, but some people who will recommend because it's in their interest to recommend that entity to do a deal rather than maybe your existing incumbent lawyer, for example. So you just need to be careful about the source of that recommendation. But normally that's a fantastic start and normally a fantastic end. Experience and expertise, not just the individual, but the team involved, and the team in terms of its expertise, but also the strength in depth that the law firm has. And that's particularly illustrated in DD, the various experts in their fields, like Penny, but also, you know, as I say, having that strength in depth as well. Self-evidently, but a lawyer in a law firm which can run a transaction is used to doing the work. And actually, bizarrely, you may think me to say this, but a lawyer who can fit in. I had a transaction quite recently where the incumbent lawyer was stood down because the way in which he was interacting with the buyer was so difficult for the buyer. I think he was being very confrontational and taking points when he shouldn't really have taken points. That the buyer wrote to the seller and said that they're pulling out because they couldn't work with his lawyer, and I actually came into the deal by recommendation, which was very nice, and we actually got that deal through to a conclusion. But it was actually a very real example. It's very easy to say these things without examples, but there was one I saw 3 months ago, which actually happened, that someone literally, you know, wasn't fit in those parties' eyes to be involved in the transaction. And I think that comes to my last point as well, really. Most important is relationship. You've got to, particularly in this small mid-market space, you know, deals between 2 and 20 million, there's going to be a lot of time that you spend with your advisors and your experts. And in my view, and maybe it's just a personal thing, whether it's social or whether it's business, you have to get on with people. I suppose the very fact that we're all involved in the Hearts Chamber is testament to that, because this is a great group of people who do get on well and work well together. So that, I think, is really important. I can't underestimate the number of hours sometimes that you will spend with a lawyer, which probably will make some of you think you need to sit down immediately and take a rest. But I can promise you, it's normally not that bad. So what does the lawyer do? Well, once helped with the heads, essentially the lawyer's job is to paper the transaction. So the due diligence, which we'll talk about in a moment, will start, and the buyer will ask lots of questions. The lawyer on the seller side will help the seller to get its information prepared, questions answered, and will help with the information as it goes through and the questions that are being asked. Acting for the buyer will review certain aspects of the due diligence for the buyer and then report to the buyer on that due diligence. Whilst that's all happening, at some point, then the buyer's lawyer will introduce the main transaction document, which is the sale and purchase agreement, and various other documents that might be particular to this transaction. So if you're selling shares, there'll be a sale and purchase agreement, the tax covenant to deal with any tax issues that might be sitting within the target company. There may be employment contracts or consultancy agreements. There may need to be something called a transitional services agreement if, for example, there's a I talked earlier about moving a division out if the buyer didn't want both divisions in the company. Well, there may be some crossover needed in terms of services, maybe IT or premises space for a while, and there may be something that normally we would call it a transitional services agreement to effectively document how those things will be dealt with between the parties. And there'll be ancillary documents, the various minutes, forms for companies' house, etc. And the lawyer's job really is to go through that whole process, negotiate and finalise the deal. And that includes dealing with a lot of the practicalities and knowing the current market conditions. Obviously, we've been wrapped up in COVID and very different ways of working for the last year. And although in the initial months of the first lockdown, it really went very, very quiet in terms of deals, by the end of the summer, it was really ramping up again. And people really learned to do deals in a different way. But I think because as advisors, we spend so long in these sorts of meetings advising and negotiating, probably got more experience in doing that than many others. So we're able to sort of help control and deal with those meetings on a constant basis. And also, obviously, knowledge of the prevailing emergency legislation in COVID, with in terms of holding meetings. There are particular regulations which allow virtual meetings to happen instead of, even if your articles did say that you had to hold meetings in person. And also, I think one of the good things of COVID, and if I can put it like that, is that there will be a bit of a sort of modernisation of how some of the institutions, like the Stamp Office and Companies House Act, in not requiring original documents, but just being able for us to deal with much more online. And obviously, signing is an important practicality, getting the deal over the line at the end of it, and many more details as you would expect, are now being dealt with by electronic signature platforms. And that just makes it an easier way to work through. The deals can be done without doing that, by scanning and scanning back signature pages. That is a little more time consuming. It does depend on the platform that you're using though, and some are still quite clunky. And there's a particular point to note about signing, and that is most deals will involve documents which need to be signed by deed, and deeds need to be witnessed. And there's quite a lot around how one can effectively have a deed signed and properly witnessed on an electronic platform. But most of them are sort of starting to deal with that. And it might include a lawyer actually watching on video a person signing and a witness in the same room pressing electronically as well. But there are different ways of doing it. Interestingly, actually, we always tend to say you shouldn't have a deed witnessed by a family, your signature witnessed by a family member. There's nothing in law to stop that. It just comes down to evidence if ever it was questioned. There's a closer relationship, obviously, in a family than between third parties. Nothing to stop that. What you can't do, though, is have the deed witnessed by another party who's interested in the contract. So if you had two sellers, one seller couldn't witness the other seller's signature. So next slide, please, Sarah. Just a few points on legal due diligence, and really the two key words are preparation and order. And the data rooms really are a means of facilitating that preparation and order. The seller will know the issues that are in its target company, although Penny might surprise you on what she's going to talk about in terms of her DD. I won't spoil that surprise for you too much. And the buyer will need to be prepared as to who will look at what. If it's a large organisation, it might well do some in-house, but it will ask lawyers to do other bits, and its accountants to do other bits still, or even its in-house finance function. It's quite important to get that right, so there isn't, well, from its point of view, double counting and people doing the same job twice, but also bombarding the target company and the sellers. And the buyer will need to decide what level of DD to do, whether it's just a sort of headline red flag due diligence exercise, or whether it wants to go into much more detail. And of course, can pick and choose from that. Some areas it may require very great detail, because that might be the core area that the target is trading in. And the seller, I mean, in an ideal world, you would have all of the ducks in a row, so all employment contracts clear, all commercial contracts with suppliers and customers all sort of set out and ready and ordered. And basically, the better prepared you are, the more smooth the process will be. If it's also important to think about who the buyer is, if you're a seller, because there will, and experts will be able to help on that. Because, for example, you know, if I'm being very general here, but if you've got a US purchaser, the idea of environmental liability is probably exorcises that type of buyer more than perhaps a buyer in the UK. So even if the target company is a warehouse on a greenfield site, there's going to be much more resistance to not having lots of environmental warranties. If it is a warehouse built on a dirty site on top of a coal mine, for example, then that goes down to risk allocation in the deal. And maybe if there is a real risk allocation issue, then it may be that things like warranty and indemnity insurance might be considered, for example. So it depends on the circumstances as to what. But knowing preparing and knowing what the seller and the buyer respectively might want is actually quite key in getting a smooth process through. And why do you need order? Well, the same reasons I just mentioned, preparation really. It smooths the deal, there's less angst amongst the buyer and seller, and less questions. So if you've got a particular, I don't know, piece of litigation involving an employee and you get asked a question on it and you don't really give an answer which is clear, let's imagine there's no underlying issue with it. But essentially, you just haven't quite answered the question clearly, you haven't perhaps provided all of the documentation for it. What that's going to lead to is a nervousness on the buyer's side because it's going to think that there's some issue, which will lead to more questions. And actually that just makes the whole process less smooth. And it actually, in the worst case scenario, makes the buyer suspicious about that, and the buyer will start asking questions on other areas which it might not otherwise have done. So that keeping ordered is really, really important. In my experience, though, buyers do need to be aware of seller overload, particularly in that sort of small mid-market area, because if you had a large buyer bombarding sellers, actually there's an issue that the seller takes its eye off the ball, and the very prized asset that the buyer is looking to acquire can be damaged because the seller isn't running the business properly. And in a recent deal that one of my colleagues was doing, we did actually ask the buyer to stop because it had just ground down into such fine detail that it was actually not doing any good anymore, and that was taken on board, and we moved on. Quick mention on data rooms. Electronic data rooms are the norm now, and I would just make a very important distinction between a properly functioning, fully functional electronic data room and simply a repository for documents such as Dropbox, because they do very different things. And actually, I mentioned earlier an example of good advisors advising on DD, and one of the best bits of advice is at the very beginning to avoid the temptation to sort of use a simple repository and not invest and go with a proper data room, because it will save real hassle and real cost in terms of what happens at the latter stages of the transaction. A good data room will have proper indexing, can change around the order of documents, search documents in a much more intelligent way. As a seller, you can keep control of who, or as a buyer, in fact, keep control of who's looking at what. And so it just gives you a pattern and some quite good data as to how the deal is progressing. Can be set up and ordered as you wish, and we'll have functions such as a question and answer session, which is actually quite a good way of asking additional due diligence within the data room setting. And if it's properly ordered and organised, we'll save an awful lot of hassle later on, because most deals these days will have the data room as being disclosed against all of the warranties that the seller will be giving in the sale and purchase agreement. Next slide, please, which is my last slide before I introduce Penny. So just talk briefly about relevant due diligence, because it's all very well going off and just sort of putting everything under the sun in the data room, and equally a buyer just scattergun looking at everything. Proper due diligence should be sector and business specific, major in the areas where the value or the risk is. So if you're a pharmaceutical company looking to buy another pharmaceutical company, you'd be looking at the patterns, third-party manufacturing arrangements, looking at reputation to make sure that all the pharmacovigilance, to make sure that things are as they should be, and that you're not buying into a can of worms. If you're looking at the garage, which is on a dirty site, then environmental, I mentioned earlier, might be very relevant due diligence, and as a seller, you'll need your ducks in a row to make sure that that has been managed. And then secondly, the macro landscape specific. The two, it's very easy to talk to this point at the moment because of COVID and because of Brexit. Due diligence at the moment is there are a lot of questions around the COVID type reliefs that have been put in place. So has the target actually properly complied with the coronavirus job retention scheme and the furlough provisions? Has all the financing that it might have taken, CBILS loans or whatever, have they been properly documented, repaid when required, etc.? So that whole thing around the legal, the financial and the regulatory areas. And Brexit as well, if you've got a company which trades across the EU, what has that company put in place to deal with that trade in the EU, places of business, authorised representatives, the things that are changing have changed because of Brexit. That's very macro landscape specific at the moment, and deals come and go in terms of that. The obvious best example of a very of the moment macro landscape thing was the year 2000 and the whole issue of computers and IT systems all falling over. So there was a huge amount of due diligence done on that issue at the time, and actually nothing did fall over. So it sort of looks quite. I remember so much energy spent on that at the time. Quite interesting. Talking of interesting, I've talked for a little while about a very sort of generic scenario. I'd like now, please, next slide, please, to introduce Penny Bygrave, who's a very experienced commercial lawyer, has a wealth of experience in information law and IP, and is, in fact, a regular contributor to our corporate team's M&A transactions. So, Penny, over to you.
Thank you, Richard. Funnily enough, I had a deal recently where I had to explain to a junior lawyer, just looking at the warranties, and said, I just don't understand what this. I have no idea what they're getting at. And I looked at it and said, they've used a very old precedent. That's the old year 2K. That we weren't that the IT systems will continue to work after the millennium. You don't see them very often, but an old precedent they do still sneak in. So thank you very much, Richard, for inviting me along today and to help to share me your comments. I'm going to look at some common issues in three areas, or quite briefly, not forensically. But to start with, I'm going to ask a couple of questions. So we're going to be thinking about data protection, intellectual property, and IT. So my first question to all of you, if you were selling your business now, how comfortable would you be with a warranty that the target has at all times acted in full compliance with all applicable data protection laws? That poll's going to pop up, and you're going to have 5 choices in a moment. Yeah. Would you be very comfortable that you've always complied with all applicable laws? Reasonably comfortable? No idea. Uncomfortable or very uncomfortable? Let's just see who. No, I can't see on my screen when you've all responded, but that should pop up now. Okay, so a lot in the don't know character category. Very pleased to see some in the very unreasonably comfortable, but I think we've got over 50% would be don't know, uncomfortable, or very uncomfortable. That is the first warranty that you're usually asked to give on data protection. And because of data protection being so broad, it is a tough one to comply with. And we'll come back and just think about some of the data protection issues in a moment. But I have a second question along similar lines. So that's question 2. If it should come up in a moment. Sorry, next slide, yes. And then next slide, next bowl. So again, thinking of yourself in the position of seller, are you able to identify all the IP owned by or licensed for use by the target? So yes, you can identify everything, and you've got copies of all the relevant documentation. Option B, yes, you think you can identify all the business critical IP, and again, have copies of the documentation. Yes, you can identify the business critical IP, but you wouldn't know how to document it. And then D and E, we don't know what IP we have, or we don't have any IP. Okay. Now, interestingly, 15% of you have said we don't have any IP. Now, a deal I worked on with Richard's team recently, that's what they answered in in the initial due diligence. We don't have any IP. And a few months later, when it came to the day before completion, we were on the phone at 10 p.m. negotiating the databases, because actually the entire deal nearly fell down, because actually ownership of the IP in the databases that the company ran went to the very heart of the deal, and the buyer potentially could have walked away. We don't know what IP we have. That is where I find a lot of clients. I'm glad to see that there is a good majority of you that think that you could certainly identify the business critical IP. But that last question, we don't have any IP. I would be very, very surprised for those of you that answered that. So that's you don't have a brand name, even if it's not registered. You don't have copyright in documentation that you publish. You don't have any databases with database rights. So intellectual property, you almost certainly do have IP, and you will almost be certainly required to warrant that the buyer will acquire good title to that IP. So moving on to the next slide, some of the key issues. So when you do due diligence, often from a starting point with data protection of people simply not knowing, and I think that's where the majority of you answered, what data you have. So with data protection at the moment, we have a very interesting regime. We are in the UK, we are having to abide by the UK GDPR, and if you are entirely onshore in the UK, then that is the UK, that's the legislation that will apply to you. But we also have legacy from the EU GDPR, and if any of your customers are in the EU, if any of your if you're targeting data subjects in the EU, then you've got 2 regimes to apply that you have to comply with. So that broad warranty that you've applied with all applicable laws means that you would need to be thinking about the EU and the UK laws. You need to know where your data is in order to be able to know whether or not you're using it in compliance with the laws. So what some buyers do what some sellers do in anticipation of a business or share sale is that they may instruct experts to come in and do a data audit. Now, first of all, I would say at all times, whether you're selling a company or not, knowing what data you have, what you use it for, where it's kept, who it's shared with, how it's protected, that is an obligation in law anyway. It's called the accountability obligation under GDPR, and it just, to me, makes business sense. However, a deal I was working on shortly before lockdown, the sellers had spent a five-figure sum on a big four audit. They weren't a huge firm. They were a medium-sized firm that spent a lot of money on a forensic audit by one of the big four firms, and actually that was the worst thing they could possibly have done, because that 100-page report identified so many problems that having spent all that money on that report, it ended up with us having to give a whopping indemnity because the report identified so many potential compliance problems at a forensic level that were then disclosed to the buyer. The buyer was then worried about the business, wrongly in my view, because the sort of things that the reports identified were not business critical, and the report had identified things that needed to be repaired immediately, but long-term problems which would be fixed over time. So that advisor had not understood what the company needed. The company needed to understand what were the critical issues that it could put right before the sale, not a whole list of long-term issues that may or may not cause problems down the line. Now, as a buyer, you do want to know that, but as a seller, that's not necessarily the best use of your resources, and it actually could create more problems than anticipated. So doing the right audit, getting the right advisors in to get the business ready for sale is important. And just because they are the big four and very expensive does not mean that those organizations will do an audit and provide you with a deliverable that is helpful to your sale. So think about what you want as a deliverable before spending a huge amount of money on an audit. But do think about an audit. If you genuinely do not know what personal data you have, you are going to be asked to identify it. So that's that. The warranty. Can you say that you complied with all applicable laws? That could be the UK and it could be the EU. So you may need to engage overseas lawyers, but think about whether or not that is critical to the business, and think about perhaps softening those warranties with with material compliance as opposed to an absolute obligation if you can't give that. Intellectual property due diligence. The buyer wants to know what it's getting. The seller needs to know what IP you own. So what do you own outright? What do you license from third parties? And particularly with that, those third-party licenses, do you need to get consents from third parties? Again, this comes back to understanding your business. And the example that I gave about the company that said they didn't have any IP, when the key asset that the buyer wanted was a database. Now, the information in that database, unfortunately, wasn't personal data. That was a sad. Otherwise, the whole thing might have collapsed. It was information that the target had acquired from various online public sources. But just because the information that you've collected into the business was acquired from a public source doesn't mean that there isn't any third-party IP involved. Doesn't mean that you don't need a license to use it. And also you need to look at the terms on which licensed deliverables to third parties from the business. If you don't know what IP you have, you do not know what you can assign to a third party. And again, you will be asked to give a very broad warranty that you have the rights to assign or license the IP. when it comes to the business transfer. And similarly, IT is very. I didn't ask the same because I think we probably would have had. I would be very surprised if we didn't have a similar answer. If I'd said to you, what IT does your company use? I think most of you would have said that you don't know. You don't know everything, because especially in these days of availability from the cloud, we're downloading software that we use in our business all the time. It's easy to access, it's cheap. But if we have built our business on the basis of using that software, do you have the license to be able to transfer that system, that software, to a third party? Very often those off-the-shelf generic licenses are personal to the target. So if it's a share sale, that will be fine. But if it's an asset transfer, that you could lose that IT if they could just switch you off on a change of control. So those are the quick run through some of the key problem areas where we say we can get down into the huge detail, but preparing for the sale, do make sure you get the right advisors in at the right times and ask them the right questions. Otherwise, say, you could fall foul, as my client did, of getting unhelpful answers that could knock your deal over. And on that note, I'm going to pass back to Richard.
Thank you, Penny. So yeah, just a conclusion really on, the ink has dried, as I said at the beginning, but the advisors, the experts' job is not actually over at that point. So four particular things I'll talk to quickly before we move to some questions. Once the target has been purchased and you're the buyer, then obviously there's a commercial imperative to make sure that you get that sort of merger dividend from the transaction that you've done. And businesses that don't truly integrate themselves, for the most part, there can be exceptions, that will tend to really struggle on that score. And so there is quite a lot of legal work and expert work to deal with on that integration. So, for example, one of the most common things that happens afterwards is the buyer wants to harmonise the employment terms of the target that it's acquired with its own business's employment terms. So there'd be work around that. If it's a very big company, that often gets done by the HR or in-house legal teams at that company, but there can be quite a job for lawyers in terms of getting that and advising around how one can do that without causing a legal problem. To take Penny's point about data protection, you may find that it's not quite compliant, but the buyer takes a view because it's not deadly serious. There may be a job then in getting data protection advice to make sure that that target company is then compliant after the event. And there may be very specific issues around the crown jewels, for example. I'm talking again about the pharma company with the trademarks and with the patents, making sure that you do an audit of those really business critical assets to ensure that it's all everything is where and how it should be, and maybe a little bit more of a deep dive than you might have done in the due diligence. The second area is restructuring. There may be particular tax reasons or risk mitigation reasons, which mean that the business you might think about changing the group shape from where you ended up immediately after completion. For example, just at a very simple level, the business of the target might be identical to the business of the buyer or one of its subsidiaries, and you may wish to hive the business across to that subsidiary and then make the target company, the entity, dormant and shut it down after a while, just because commercially you don't actually need it. You need to be aware of doing things like that, because sometimes in a transaction you may have, as a buyer, certain restrictions on doing things for a period of time. So there may be an earn-out in the SPA. So you get a certain amount of money up front and a certain amount depending on how the business does in the next few years. Earn-outs from a seller's perspective, the seller will want some protections in there, and one of those protections might be to keep the business running on its own. So it's very transparent as to how that business is performing, and therefore that then has a knock-on effect on the earn-out that the sellers will receive. But there are various reasons why one might restructure, and obviously quite a lot of work involving advisors on that element. There are post-completion tasks, from the simple putting a Bible of the transaction together so that all the parties have the documents that are part of the transaction in one place. There will be almost certainly some form of completion accounts mechanism, so that at completion there will be an account taken of the financial position of the company compared to perhaps, say, the last audited accounts. And on that basis, you may you'll have your accountants who are preparing or checking the completion accounts to make sure that they comply with the provisions that have been negotiated in the sale and purchase agreement as to how those accounts will work. Lots of filings, Companies House, stamp duty. If you're the buyer, you have to pay stamp duty on the consideration that you've paid. And simple things like company secretary and registered office and change of accountants and change of bank mandates. A lot of those things can be done by the business itself, but often we find ourselves getting involved in some of those issues. And actually, one thing sometimes our tax team gets involved in is helping sellers with tax returns that often one would provide in a tax indemnity in an SPA. An ability for the sellers to input and conduct and maybe conduct. Buyers would often resist that for obvious reasons. The going through of tax returns with HMRC, because obviously if they relate to a period where the sellers have actually been running the business, and the sellers, from the buyer and the seller perspective, might actually add value to the process in helping those go through smoothly. And also the thing that finally that people don't want to talk about, which is when something goes wrong. You know, there may be a warranty that's been given in the SPA, which is the protection for the buyer, which actually has been breached, and there is a loss that the buyer has suffered, and that might lead to a formal breach of warranty claim, and obviously lawyers and experts will be involved on both sides in trying to deal and get that breach of warranty sorted. And that might end up, or probably usually would end up, with a settlement, and it's because of those sorts of threats that very often in a sale and purchase agreement you would have a retention very often for the buyer for a period of time to use against particular warranty claims. Doesn't mean the buyer can just simply take the money. It has to go through a certain process, and that it just means that the money is safeguarded, so it is there if the warranty breach is actually real. And another final example of something going wrong, maybe the sellers have signed employment contracts to continue to be involved in the business after completion, but find it really difficult to work for someone, very frankly, or in the environment that the buyer has, and want to walk away. And so you'll often find lawyers involved in a negotiation around early termination of those contracts, or around restrictive covenants which are involved in those contracts. So hopefully not something that will happen, and doesn't happen on most deals, but things sadly do go wrong at times, and that's where you need that help. So that's all part of the formal talk from Penny and I, and we now on to questions and answer session, and we'd be delighted to answer some questions. So maybe Gemma, perhaps over to you, I think, to ask.
No, thank you, Richard and Penny, for that informative presentation. We do have one question, so just to let you know, guys, the slides will be shared, and And if you do have a question, you're more than welcome to put it in the chat function or raise your hand and we will come to you. So Tracy Whelan is asking Richard, in your experience, what is a typical earn out timing and structure for a services company?
Typical timings on earnouts would, it does vary, but you probably find you go two years is a sort of typical earnout timing, and whether it's going to be a full profit earnout or whether it's earnout on turnover, I suspect with a services company you might find it's more skewed towards profit. If I'm a seller, I'm going to make sure that earnout is as prescriptive as possible so that I can make sure that I get my money. And profit earnouts are notoriously difficult because obviously, profit can be interpreted in very different ways, and you can quite legitimately pull different things into the accounts to set against that profit. And so you would have quite a detailed earnout schedule, which would try and put all of the rules around it. But it's impossible to be completely and utterly prescriptive on that side. So if at all possible, go for something which is more transparent, like a turnover. But I think you might find yourself tending towards profit on that.
Thank you.
Thank you, Richard. Right, so we have one for Penny, so from Alison. How do we know what unregistered IP we own?
Sorry, you'd think after this amount of time I knew how to unmute myself. Really interesting question, because very difficult to know what you own or indeed what you're licensing. The registered IP of the company, obviously, if you've taken the steps to register your brand, your trademarks, that's clearly identifiable and that's easy to disclose. But as a business, as I mentioned before, you will almost certainly have copyright in documents that you produced, whether that's brochures or you'll have your websites. There'll be all sorts of things where you will have unregistered rights. So it comes down to, I would say, if you are thinking of selling in preparation for the due diligence, a mini audit of your assets and thinking about then what intellectual property arises from them. So, for example, that case that I was asking, that database was the key assets that organization owned, and it was the key asset that the buyer wanted to or one of the key assets that the buyer wanted to acquire. So if you've built a database, whether it's of people and contacts and names and with personal data, and that has its own issues, or whether it's just information about analytics about previous deals and how things have gone well, there is intellectual property in that database. So think about all the things that you use that are critical to the business and that you rely on, and then do some sort of internal or external audit to say what do we own this outright? Who created this? If it wasn't created by an employee of the business, chances are that you won't own it outright, because unless you've got a formal assignment, and if you didn't know you were creating IP, how would you know to ask for a formal assignment? Coming back to your contract documentation, it all works together. So as long as all your standard supplier contracts provide that they assign ownership of deliverables to you on creation or on payment, then that's a big tick in the box that you will own everything that they've designed for you. But if you don't have that contract with the developer, with the supplier, then you may not own rights in things that you've paid for, and you think are yours, but if you haven't dotted the I's and crossed the T's historically, then you may find that you don't own everything. Some form of audit I would highly recommend. However, I would also say do think about who is doing that audit and what the outcome is that you want to achieve, because paying a lot of money for the wrong type of audit and report is just not helpful.
Thank you, Penny. I'm going to come to Colin Locke now. So he's got a question, I think, for Richard.
Yeah. Gemma, thank you very much. Richard, can you hear me?
I can, Colin, loud and clear.
Very good. Hello, Richard. Richard,
Hi.
it's a question around due diligence with particular reference to human resources, HR. Now, I appreciate that, what I would call big ticket items are looked at during the due diligence process, director service agreements, remuneration packages, etc., etc. In your experience, particularly when the target is a small to medium-sized SME, are other HR costs and obligations looked at? Things like absenteeism and the costs associated with absenteeism, labour turnover and the costs associated with that, recruitment practices and procedures, learning and development plans, all of which have not a significant cost by themselves, but cumulatively can add up to quite a chunk of money. In your experience, are they looked at, or are they not considered to be relevant?
I think it depends on the deal, but they should be, and they mostly are. So it would be a combination of the actual legal due diligence on some of those things, like absences might come to disciplinary, and therefore how a buyer would have to deal with those things, and could lead to, have the procedures being followed on absences. So if for example, the company had just let absences go and been very lax about it, that might cause the buyer a bit of a problem, and so therefore it would want to think about that. The other things are probably, or some of them are the other aspect of it, is that sort of knowing your target, if you like, and just understanding its business practices and how it works. And I think that will come from a proper HR to HR type discussion and getting comfortable with the culture, if you like, of what's there. So I think, Colin, it's a combination of both.
Okay, that's all. Richard, thank you very much.
No problem at all.
Thank you.
Right, it seems that you were quite popular, Richard. So we've got another one. So from Niketh Shetty, Richard, how will things change when it's a case of a merger instead of a buyout?
So that's interesting, because we say very generically mergers, acquisitions, etc. A true merger is actually something that happens very, very, very seldom in the UK, and we use merger as a term for one party buying another. There is a history for us now, but there is an EU directive which deals with the true merger of companies, and a true merger, and there's a particular procedure which we've done a few times at VWV, is effectively, and it's normally two different countries in the EU coming together, and literally it needs to be court approved, and they literally one merges and disappears to the other, whereas in the UK it tends to be one, so a buyer buying another company, that company becomes a group company of the buyer. So it's not a true merger of the entity. The true merger, I suspect, happens when, well, not I suspect, does happen usually when you might hive the business up into the existing business of the buyer, and then the company disappears. But in the actual legal sense of the word merger, it doesn't quite happen in that way. But but to answer the question very, very simply in terms of due diligence, it will be the same issue in terms of due diligence. You want to know all the same things and undertake the same processes.
Thanks. And then we've got one final question, which is from Kennedy Mashanda. In preparation for a future acquisition, are there capital gains tax implications and share allocation structures from previous issuance of shares to co-founders the business should be aware of?
So shall I just take that? I'm not a tax lawyer. Sorry, someone tried to call me. Sorry about that. I'm not a tax lawyer, but essentially things around capital gains tax will depend often around how long you've held those shares and the way in which you've held them. And a common example of where people get into trouble with CGT is perhaps where you might have options granted. And if you grant what's called enterprise management incentive scheme type options, then you do it in a particular way, then that can be very CGT advantageous. But if you don't do it in the right way, then that can cause a problem if, for example, you want to give shares at the last minute. In terms of issue of shares to co-founders, well, it really depends on how you want the consideration to end up, and if those shares are issued in the right proportions, then there's really no issue you should worry about, unless you've only held them for less than a period of time, 2 years. And if they haven't been issued properly, that can be an issue, because you then might find that you haven't held them and you have to do some sort of restructuring, and that then might cause you a tax issue. Also, if you move away from tax and look at just actual law and transferring the legal title to shares, if they've not been properly issued or if there's been some problem with that, then that can cause quite an issue. And on deals, you often find maybe there's a co-founder who's long gone and the shares haven't quite been transferred properly, and that will lead to some issues. But normally there's a solution found, and it might be just simply an indemnity if both parties can get comfortable that it's not really going to be an issue. But it can cause additional time and expense, and it's important because it goes to the root of what the buyer is buying, i.e. the title to the shares.
Lovely. No, thank you, Richard, and I hope that answers your questions, everybody. Well, thank you both, Richard and Penny, for giving up your time this morning, and I hope you all found it of benefit. So just to close quickly, our next Entrepreneur Foundation session will be on the 6th of July, and that is sales skills, learning how to become more effective with Brandwin. This will be open to the public as well as our entrepreneurs. You may have seen, for our members here, the Connects platform, which we have already launched, but we do have a launch event on the Thursday, the 1st of July. And this platform is all about how to build trusted business relationships online. If you want to know more about this platform and how to use it, please do make sure you attend that one. And we are running our first live event finally on the 8th of July at Hatfield House. So this is going to be a business breakfast networking session. Places are limited, so if you are interested on that event, please do get yourself booked on. And finally, we are running the Peer Networks program again. You may have seen what this is, or if you want to know more information, please do look on our website for more information, or do contact one of the chamber members of staff who will be more than happy to explain to you what the Peer Network program is and how it can help your business grow. So thank you all for coming. Enjoy the rest of your day, and we hope to see you soon at a next event. Right, take care all. Bye bye.
Thanks, Gemma. Thanks all.